So let's step back and take a look at what we did in the last class. We went through the three elements of forming a contract. And we went through what happens if contract is not performed. If it's not performed, usually it's breached, but there are times that it's not considered breached. It is when the condition to the contract's legal effectiveness has not been satisfied, or a contractual obligation has been discharged due to force majeure or other conditions that took place after the formation of the contract. Now, if the contract has been breached, after that we went through what happens when the contract is breached. So we talked about remedies. We decided that the non-defaulting party can terminate a contract and also seek damages. And we talked about different rules concerning damages that the non-defaulting party can be entitled to. We talked about when liquidated damages are valid. We talked about how consequential damages are usually not covered by contract law, and how contractual damages are usually or will usually fall into special damages as opposed to general damages. Okay. Now, the third remedy that a non-defaulting party can obtain is injunctive relief. Repeat after me, injunctive relief. Injunctive means having the nature of an order, a court order. So this is a time where court orders the parties to do something or not to do something. Now, for some reasons that we don't need to go into in detail, injunctive relief is not a preferred remedy in Anglo-American law. Injunctive relief is obtainable. Injunctive relief can be obtained only when money damages are inadequate. If there are ways to compensate the non-defaulting party with the money adequately, then the non-defaulting party cannot get injunction. So even if you prove everything against the other party, that a contract has been formed, the condition has been satisfied, contractual obligation was not discharged, and a contract has been breached, you still cannot get injunctive relief unless you also prove that money damages are not adequate. Why is that? Well, we don't know why. I mean, we don't know the ultimate reason, but we can make sense out of the fact that in Anglo-American law, there's a strong law of contempt of court. Repeat after me, contempt of court. Contempt of court is far different from 법정 모독죄 in Korean or other civil law countries. 법정 모독죄 concerns an act of insulting a judge in a court of law or violating some decorum, some rules of courtesy when you appear before a court. Not wearing a wig or not wearing a tie in front of a judge may be considered an insult to the judge. Contempt of court is entirely something else. In Anglo-American law, a violation of judge's order is considered a crime. And because a judge knows, when his order is violated, he can himself indict a loyal or party that has not followed his or her order and put him or her into jail right away. Now, this is a very powerful remedy because if you have money, you usually want to pay off all the money before you are thrown into jail and be treated like a criminal. So a lot of times parties want to get a court order to protect their interest. For instance, you can get a judgment. You can get a judgment for $1 million in your favor, a judgment. You can get a court order ordering the other party to pay you $1 million. In Anglo-American law, which one do you think is more valuable, a judgment or order? Judgment or order? Which one will be more valuable? Order, right? If you get a judgment, all you get is a piece of paper, and you go to the defendant. Let's say you are the plaintiff. You go to the defendant and, hey, the judgment says you have to pay. Pay now. If the defendant says no, you cannot do anything other than enforcing on the judgment. 판결을 집행한다고 하죠. So you ask the court officials to attach the assets that the defendant has, and then ask the court to conduct an auction, 경매. And whatever you can get out of the auction, you cannot take it all. You can just pay yourself what's due to you. Now, if the assets are not valuable enough to cover your damages, then you are out of luck. Okay? That's all you get when you have a judgment. But when you get a court order, you can throw the other person in prison for not paying you that $1 million. Much more serious remedy. Now, who has studied Korean civil procedure here? 민사소송법. Okay. Is there a remedy like that in Korean Code of Law? No, the throwing someone into prison for not paying money or not paying.
No, unless it's a fraud, you do not go to jail.
If it's a fraud, right. If it's a fraud, then it's a criminal case. I'm talking about a civil case, right? In a civil case, you don't get a remedy like that. Yeah, that's why big companies like Hyundai, they got a judgment for wrongful termination of their employees. Not wrongful termination, but the judgment that their contractors' employees should be actually considered their own employees. But the Hyundai is not following the judgment. and yet there is nothing that the workers can do. Of course, workers can seek civil penalties for violating judge's order, but that's another case. That's another lawsuit, right? And it's not as powerful as threatening to put in jail a CEO of Hyundai Motors, right? So injunctive relief is backed. Injunctive relief is supported by the threat of contempt of court or threat of being prosecuted, being punished for contempt of court. So it is much more powerful remedy. So people want to have it, okay? The winning parties want to have the injunctive relief. And because it is such a powerful remedy, the court will allow it only when the money damages are inadequate. Okay. Now, because this reason, injunctive relief is least preferred. So the most preferred remedy is money damages. Okay. So in principle, all injuries under Anglo-American law are considered compensable with money. Okay. Money solves everything under Anglo-American law. Now, if money cannot solve something, then you go for injunctive relief. Okay. Now, if damages are not enough, then you can get negative injunction. What is negative injunction? A court order not to do something. Okay. Affirmative injunction, it's usually called affirmative relief, is an order to do something, right? So for instance, an order to pay someone $1 million, that will be affirmative relief. An order for a man to stay away from a woman, that will be considered negative injunction. Okay. Now, negative injunction is easier to get than affirmative relief. Now, it's still not preferred over damages, but at least it's easier to get than affirmative relief. Now, I told you one possible reason why contempt of court, or why injunctive relief is not a preferred remedy. Now, that doesn't really explain why. It just, I mean, my first explanation was that at least it is consistent with the fact that injunctive relief is backed by contempt of court. To give a real explanation, we'll have to do some historical analysis of law and equity. Now, you need to know this term at least. At least you know this term. Repeat after me. Law and equity. Law and equity. What is equity? Equity is also part of law. Law is handled by judges. Now, equity, when it first came into being, was handled by the king or the king's advisor, chancellor. Okay? I mean, you should just keep in mind this picture. There's a courtroom where judges issue judgments. Now, if the parties, I'm talking about like medieval times here. If the parties felt that the judgments were not fair, in a feudal time, in a kingdom, where would they go? They'll go to a king. They'll go to a king's court and then ask for something that's more fair than what judges did, right? Because there was not really modern rule of law yet, right? Law was not at the top of everything like now. In the time of monarchy, king is at the top of the law, is higher than the law. So people who receive judgment on the law and found it unfair will go to the king. And the king will make his own judgments about what's fair or not. That was considered, and those judgments, those king's judgments, made the body of law called equity. And I'm suspecting, and many are suspecting, that this difference between law and equity, and of course, king's words, what king said, if it is violated, of course, king could punish the person who doesn't follow his order, right? So that powerful remedy was only with the king's court, not with the court where these professional judges make decisions. So there is difference between, there were two bodies of law, two different bodies of law, one called law, one called equity, and that persisted until the latter half of 1900. Then, when the modern rule of law took hold, then they decided, okay, this doesn't make sense. All the law, all bodies of law have to be unified. So law and equity was consolidated. But still, the remnant, the relic of the past remains in the fact that you can get equitable relief, okay? You can get equitable relief only when legal relief is inadequate. Okay? I didn't write it down, but repeat it after me. Equitable relief. Equitable relief doesn't mean relief that's more fair or that's more equal. Okay? Equitable relief means relief that you can get from the law of equity. Okay? Relief that you can get above and beyond the legal relief. When I say legal relief, I'm talking about damages, okay? Money damages. Anyway, now this is about general law. Now, when it's applied to contract law, repeat after me. Specific performance. Specific performance. When it's applied to contracts, specific performance is one of the most important affirmative relief. Specific performance is an order by a judge requiring the parties to perform the contract. So if you have not delivered 10,000 baskets of apple, you must deliver 10,000 baskets of apple by whenever. If you cannot, you will be held in contempt of court. Okay? That is specific performance. So specific performance is, of course, difficult to get. You can get it only when you can prove that money is not sufficient remedy. So specific remedy, specific performance is available only in a situation where you are supposed to get things that are not replaceable. For instance, let's say your wedding pictures. Okay. Let's say one of the Photoshop. I'm not talking about the software, but the Photoshop store. Let's say they recorded your wedding ceremony and has not turned it over to you, and you cannot. No money can replace. No amount of money can replace the wedding, the footage of the wedding ceremony, right? You may get divorced and do another wedding, but barring that possibility, even if you include that possibility, that wedding is a complete event. It's a unique event to your life. In that situation, you can ask for specific performance, and judge will grant you that, ordering the shop to turn over the wedding footage. Now, when does this injunctive relief come up? In a provision like this, waiver of injunctive relief. Repeat after me. Waiver of injunctive relief. What is a waiver? Giving up. Okay. There are times that companies ask the other party to agree to a clause, a provision in a contract that waives injunctive relief. Okay. So if that provision is in the contract, the non-defaulting party, even if the non-defaulting party proves everything, wins on all the points of contract law, still cannot go for injunctive relief. Because he or she has given it up through that provision. Why would that happen? Well, for instance, let's say there's a novelist, okay, a author of a novel that was turned into a movie. So big studio like CJ in Korea bought the filming rights to that novel. Okay. Now, when CJ enters into a contract with the author, it's very likely that CJ will ask for a provision that says the author hereby waives right to seek injunctive relief. Why would CJ want that? Why would the film studio want that? Well, after the novel is turned into a film, if the novel author seeks injunctive relief, he or she can stop showing the movie. And that's too big an injury, that's too big an uncertainty that big companies can live with. Big companies have like 100 or 200 people work on that project, and being able to, and the possibility that that project does not go forward is just unthinkable. Now, it's okay to pay money because once the movie is shown in the theaters, the film studio will receive cash, will receive money, so that if the author wins on the lawsuit, the studio can pay him or her off with the money. But if the showing of the movie is stopped, then there is no money for the studio to pay the author either. Okay? It's just too risky. So big companies usually big licensees who want to make use of the rights that the licensor has licensed usually ask for this waiver of injunctive relief. Now, the other way around is that there are times exactly for that reason, licensors want to, there are times that licensors or any parties want the other party to give up fighting injunctive relief. I mean, you can fight the other party's request for injunctive relief by proving that money damage is adequate, right? Now, the waiver of defense to injunctive relief, this provision, allows the non-defaulting party, or makes it easy for non-defaulting party to get injunctive relief if he or she wins on other points of contract law. Okay? Yes?
Can you say that?
I couldn't hear you.
Can you say that one more time, please?
Waiver of defense to injunctive relief is a provision whereby a party gives up in advance fighting or objecting to the other party's request for injunctive relief. So how do you, I mean, so what would you have done? What would you have done if you have not objected to the other party's request for injunctive relief? Well, you would have tried to argue in court that, Your Honor, I breached the contract, I'll pay money, but money is adequate for the other party. The other party is not entitled to injunctive relief. Money is adequate remedy for that other party. That argument, you are giving up if you agree to, you are giving it up in advance if you sign on to, if you agree to waiver of defense to injunctive relief. Well, why would anyone want that? Well, if you want to hurt the other party as much as possible, when the other party breached the contract, then you'll want it. For instance, I told you about the author and the film studio. What if the author really wants to make sure that film is made to his or her satisfaction? He doesn't want a film that does a half-assed job of his great work. Okay? Then the only way that he can really get satisfaction of his desire is by looking at the film after it is made and then decide for himself whether it should be shown. Right? Then you want to put in a provision that says, hey, I'll go for injunctive relief. I'll go for a court order stopping you from showing the film if I don't like it. Okay? Now, usually, I told you big and small. I put in there because usually the big companies get what they want. So licensor can only ask for defense to waiver of defense to injunctive relief. Whether licensee will agree to it is totally another question. So because it is unlikely, I mean, if it is so maybe I should revise this. So usually requested and obtained by big licenses, and usually requested and obtained by the big licenses to licensee. Because the reality of the market dictates what goes into the contract. So only the big companies will get what they want, right? Any question, comment so far? Okay. If not, the very last element of American contract law is third-party issues. Okay, question. Let's say there's a contract between A and B. The contract has been breached. A third party C. Are there times that a third party C can sue A or B for breach of contract? You studied Korean contract law. What's the answer under Korean law? Anyone? A contract between A and B. Can C sue either A or B for breach of the contract? A non-party C. There are times that C can sue, or there is no time, no circumstance under which C, that's not a party to a contract, can seek remedies against A or B. Anyone?
In some cases, C can sue A or B.
What are those situations?
A and B enter into a contract for the third party.
Contract for?
제3자를 위한 계약.
Good. So you already know what I was about to lecture. Intended beneficiary. So if C is an intended beneficiary, intended by who? Intended by A and B to be the beneficiary, right? Now, the same rule of law, the same rule applies here. What if C didn't know that C was going to benefit from the contract between A and B? What happens? Can C still be considered intended beneficiary? No. Okay. Contract law requires the parties. Contract law becomes effective only at the pleasure of the parties, only according to the agreement of the parties, right? So if the C had no idea that C will benefit from the contract between A and B, then C later cannot sue, cannot make any claims under the contract that he didn't know about. Okay. Another question. Can a contract be assigned? Does contract between A and B can be assigned the contractual obligations and the rights and obligations to C, so that A and C becomes the parties to the contract. Okay, you studied Korean contract law. What's the answer under Korean contract law? Can a party transfer his right and obligations under a contract to a person, to another person? Yes. Okay. How? Or what's the procedure that the transferring party has to follow? Has to give a notice. Okay. Usually, just by giving notice, one can assign. It's called assignment. Repeat after me, assignment. One can assign one's rights and obligations, rights and duties under a contract to another party. But if assigning the contract, if turning over the contract causes a detrimental change, then you need to get a consent. Detrimental whom? Detrimental to the other party. Now, let's say you have a bank debt, right? Bank debt. Okay, who has a bank debt?
Yes.
How much can I ask?
A couple million.
Couple million won.
One.
Okay, thank God it's won, not dollars. Yes. 2 million won. Let's say the bank wants to assign the loan contract with you to another bank. Does the bank need to get a consent from you, or does the bank can the bank successfully assign the contract just by sending you notice?
I think they need my consent as long as the interest rate changes.
Yes. What if interest rate is fixed? Or even if it's a floating rate, it is floating according to a formula that doesn't change regardless of who the bank is. The answer is right here. If there is no detrimental change, if you're going to be subject to the same interest rate, then yes, the bank can turn it over to another bank without your consent. You will learn this especially when you are defaulting on your loan. There are many bad loans, or the loans that people have defaulted on, 채무 불이행했다는 거죠. Defaulted. There are many loans that people have defaulted that the banks transfer to other companies, usually called asset management companies, AMCs, that are more expert at tracking down the debtors and asking for money. 한국에서 이제 채권 추심이라고 하는 거죠. 네. 채권 추심을 더 전문으로 하는 회사에 싼 값에 주고 넘기는 그런 경우들 여러분들 볼 수가 있습니다. 그때 they never ask for your consent. They'll just do it. They'll just send you notice. From now on, we don't have we don't expect you to pay us the money. From now on, this new company will give you calls, send you text messages, will make your life hell to get the money from you, not us. Okay? Now this is the new creditor, right? Then what are the situations where there is a detrimental change? Well, the other way around. Let's say you have loan contract with the bank, and bank loans you money 2 million won because you have this job, because of you have been faithful, you have been diligent in the past. Now, can you just assign your loan contract with someone else? No, bank will not allow it, right? Because the bank made you the loan because you are that much credit worthy. And if you are turning over to somebody that the bank doesn't know, then that's a detrimental change to the bank, right? So that's all you need to know about assignment. Now, assignment also comes up in contractual provisions. So you should it comes up in contractual provisions because assignment is easy to do, easier to do than you think. See, as long as you are not causing detrimental damage to the detrimental change to the other party, you can turn over the contract to a third person. So you need a provision that protects that possibility, that protects you from that possibility, that protects you from other party, transferring the contract to a third person. Okay. Delegation. Repeat after me. Delegation. Delegation is it's not like an assignment. Delegation only means having another person perform the contract for you. Okay. Novation is entirely something else. Novation is nov. There, nov is the nov is the radical for the term novel, which means new. So novation means doing something new. Novation means turning over the contract so that you turn over the contract. So now there is no relationship between A and B. So A and C are the two new parties to a contract. So novation can take place only through the agreement between all three parties. Okay. So because novation takes place only through the agreement of all three parties, there is there's hardly any dispute. Right? Okay, that's it. You just finished the first year contract law in an American law school. Okay? Everything you would have learned for an entire semester is on this slide or set of slides. Okay? All right. Question, comment? If not, we'll go to the actual business contract, distributorship agreement. What a distributorship agreement is, it's a contract between supplier and distributor. What distributor does is buy from supplier and sells to somebody else. Okay? So there has to be a complete transaction of buying from supplier and then another transaction of selling. Okay? So it's also called reseller, right? Now, dealer and agency are different from resellers or distributors in a sense that dealers and agencies do not complete the process of buying from the supplier. They sell to third parties on behalf of the suppliers. They never buy from the suppliers themselves. So who are the dealers? When you buy an automobile, let's say you buy a Hyundai Sonata or whatever, you buy from a store that's not part of Hyundai, but when you actually buy the car, you'll see on the contract that the party to the contract is Hyundai Motors itself. So that store is only selling it on behalf of Hyundai Motors. The store has never bought any car from, when the store sells you a car, it's not the store's car, it's a Hyundai's car. Okay? So when would you see a dealer relationship? When would you see a dealer or agency relationship usually? When the products are expensive or when the products are cheap? Right. So the store selling cars, store selling expensive electronic equipment, like sound equipment, amp, right? Amplifiers. They are usually dealers. They are not distributors. Now, I told you that if it's just buying and selling that distributor is doing, then you don't really need a distributor. You don't really need a separate agreement that governs the relationship between supplier and distributor, right? Because all the distributor is doing is just buying and reselling, right? If at all, what you need is a sale and purchase contract, right? Because all you are doing is just purchasing and then selling, right? Then why do you need a distributorship agreement? Or to form some sort of relationship with the supplier. Why do you need, when do you need to form a relationship with the supplier? Well, you want to grow, you want to do business in reliance upon the market power of the supplier, right? If Apple, it's a great brand. You want to be the distributor, right? Then you want to somehow get a piece of the action. How do you do that? Well, by asking Apple to give you the exclusive right to distribute, right? Then you can sell yourself, you can introduce yourself as, hey, I'm the only distributor of Apple in Korea. Then people will pay attention to you, right? If you are just, hey, I'm one of 10,000 Apple distributors, people will not pay attention to you. Hey, I have an Apple iPhone. I bought it from Apple, and I can resell it to you. In a sense, you are a distributor of this one Apple phone. People don't pay attention to you, right? But if you say you are the exclusive distributor, then you are talking, right? Then you can not only rely on that brand, you can also safely invest money into selling more Apple equipment, right? So in those situations, you want to form an exclusive agreement with Apple, which prohibits. I keep saying Apple. I'm not here to advertise Apple. You want a promise from the supplier not to distribute through other people. Okay? That's usually the only situation where you want to form a relationship with the supplier. So that's why I'm saying when you get a contract, the first thing that you want to look at is whether it is exclusive contract or non-exclusive. If it is non-exclusive, you better tell your client, hey, you may not need this. Okay? Maybe you shouldn't invest your legal resources. Maybe you shouldn't invest money into paying attorneys to look at this contract. If it's non-exclusive, you don't really need a distributorship agreement. Distributorship agreement is usually meaningful only when it includes a promise, only when it is a promise for supplier not to sell in distributors' territory. That's what T stands for, territory. Okay? Now, yes, you'll need a sale and purchase contract with the supplier, but that can be done through back of purchase order. Just on the purchase order, you can just write down like warranties, dispute resolution clauses. They all can go under the back of purchase order. You don't need to decide all of that you don't need to decide all of that in advance. You can just submit a purchase order with the conditions you like. If supplier accepts it, then you have a valid sale and purchase agreement. Right? You don't need to go through like 6 months excruciatingly painful negotiation with the supplier for an agreement. Now, still, there are times that distributors want to go into a non-exclusive distributorship agreement. When would that be? Well, when they want to get this name, authorized distributor. Okay. So when you travel around, or when you surf around on the internet, you'll see the term, hey, I'm the authorized distributor of Nike. That means that company, that store, has a actual contract with Nike and has some favorable terms, or sometimes disfavorable terms with the Nike in getting the Nike products. Now, authorized distributor is not the only person that can distribute Nike products, right? Anybody can go to any Nike store, buy 1,000 pairs of Nike, and start distributing. Okay? There's no law stopping that. I can buy 1,000 iPhones tomorrow, iPhone 6, and start distributing. Start selling for money. There's no law stopping me from doing that. That makes a distributor, but I'm not an authorized distributor if I do that. So that one is an authorized distributor, creates this advantage in the market. right, above this non-authorized distributors. I mean, at the far end spectrum of these distributors, you have like, you know, what we usually call 보따리 장사, right? You know why they are called 보따리 장사, right? They just go overseas, they find something good, they just buy it as a consumer and make a big 보따리 and just bring it home. I mean, bring back to Korea and just start selling at a margin. Many 명품, Louis Vuitton, Chanel. There are many people who buy those things at consumer price and sell it in Korea because you can still make nice profit because department stores are selling it so expensively in Korea. So that's the difference between authorized distributor and non-authorized distributor. Okay? So to be an authorized distributor, many companies go for non-exclusive agreements. Okay. Now, before I go further, you read the contract, the sample contract I gave you. Now tell me whether it is an exclusive or non-exclusive contract. Exclusive. Okay. The more important reason, how did you know that? Okay, right. I goofed. I should not have named the agreement that way. So, is there any reason? Is there any other reason? Any other substantive reason you find? That backs up your answer? Other than exclusive. No, I mean, okay, I mean, a contract doesn't become exclusive just because it is named exclusive contract, right? There has to be a provision in the contract that grants the distributor exclusive right to distribute the products in the territory, right? Is there such provision in the contract? There we go. 1.1. Subject to all of the terms and conditions set forth in this agreement, ABC hereby appoints distributor. And distributor hereby accepts such appointment as ABC's exclusive distributor of those products specified in attachment A in the territory in the right to market, sell, support products solely from marketing and sales outlets within the territory. Okay? So, it says ABC's exclusive distributor. Now, being exclusive means exclusive even to yourself. Okay? If once ABC agrees to this, ABC itself cannot sell in the territory. Okay? Now, once we know that this is exclusive, then you can safely invest time reviewing this contract. Okay? Because now we know that this contract means something. Okay? So when a client sends you a contract for review, the first thing you check is it exclusive or not. If it's not exclusive, okay, go home. Call your client on the way home. Okay? Just tell him, hey, that contract is not that urgent. I'll call you tomorrow. Okay? If it's exclusive, then you have to pay some attention. Yes?
Even if it's authorized, distribution agreement, you still call your client, right? You don't need to read the agreement.
Well, I mean, all agreements form the quote-unquote authorized relationship. All contracts will give you the title, the authorized. But as I said, you want to be the authorized distributor only to show to the market. There isn't really anything substantial you get, right? I mean, some of the authorized distributors will probably will hate some of the terms in their contracts with the supplier, with a big name supplier. Some will wish that they were never authorized distributors. You know, couple relationship, right? Can be really bad, right? But so whether it becomes a authorized relationship or not, what I'm saying is the amount of attention that you have to pay, depending whether a contract is exclusive or not, it just varies widely. Okay, let's say it is exclusive. What do you need to look at? Well, if it is exclusive, you want to know what right, what exclusive, I mean, to what products you are getting the exclusive right. Well, to what products you are getting the exclusive right. Okay. If it's Apple, are you getting the exclusive right to all Apple products? Or are you getting exclusive right only to Apple iPhone, not iPad? Okay. And none of the Mac, you know, none of the Mac notebooks, right? So scope of exclusive products is really important. What does our contract say about the scope of exclusive contract? That's the first thing you want to look at when you get an exclusive contract. What is the subject matter of exclusivity? What does our contract say? What's the supply? What are you selling? What's your client selling? Come on, quick. You're not fast enough.
Product specified in the
Good.
attachment.
Product specified in attachment A, and we don't have attachment A. Okay. So what is in attachment A? I mean, usually you think that attachments are not as important as the main contract, but no, attachment can be and are usually more important than what's in the main text. Now, one tip. Repeat after me. Upgrade.
Great.
Improvements.
Improvement.
Next generation.
Next generation.
Replacement.
Replacement.
And key parts thereof, including OEM.
Including
Okay. One question I got a lot. Attachment A, in the sample contract you have, attachment A said KX 100. Okay? KX 100. Later, distributor finds out that supplier is selling in the distributor's territory. Okay? Here is supplier, here is distributor, and it's distributor's territory. Supplier is selling KX 200. Which is competing in the market with the KX 100. has supplier violated the distribution agreement? That's a question I get often. Let's say it's an upgrade of KX100. Is this a violation of distribution agreement? If the contract's attachment said KX100? No. Okay? If you are getting something, there has to be a specific provision giving you that. Okay? If the contract said KX100, all the exclusive right you have are to KX100 and only KX100. If you want to protect yourself as to the loss of market coming from the upgrade, you will want to put upgrade in attachment A. Right? So KX and its upgrade. Now, sometimes upgrades is not enough. Let's say KX100 is KX100 is a vacuum cleaner. And let's say KX200 is a vacuum cleaner with steam with a steam wiper function. It not only vacuums, but it also wipes with the steam. If a supplier sells KX200, is this a violation of the exclusive distribution agreement? The answer is, well, if the contract only said KX100 and its upgrade, it's very possible for supplier to argue in court, hey, this is not just an upgrade, this is a new product, and supplier may win. Okay? So to cover yourself, you want to put something like upgrade and improvements. And on, right? Next generation, okay? What if the KX200 not only vacuums and steams, let's say it does it by itself, I'm sorry. It's a robot, okay? If you just turn it on, it just cleans the room by itself. If you want to cover that, you want to add next generation. And then there are these new robot vacuum cleaners that go up the stairs. Okay? They clean not just one room, they clean the entire house. Okay? You want to cover that, you want to write down replacement. So replacement will be any product that competes with KX100. Okay? So any cleaning equipment, any automated cleaning equipment developed by supplier, you will have the exclusive right to distribute in the territory. Now, there are even crazier possibilities. Let's say supplier doesn't sell the completed products, let's say the supplier sells only the key parts. I mean, for any electronic equipment, there is that central part, the core part, right? And then all the periphery that really makes the connection between the consumer. I'm talking about consumer equipment, okay? The peripheral products that make connection between the consumer and the core part, right? What if the supplier sells only the key parts to some shops in Yongsan, and in Yongsan they can make anything and everything, right? So with the key parts, they make something that competes with the KX100. Is this violation of the contract? It may not be. So if you want to cover yourself as a distributor, you want to put and key parts thereof. This is not a theoretical possibility. This happens often. Okay? As a lawyer, I've seen this. Because the contract didn't have this term, key parts, we had a hard time. Now, what if supplier sells not KX100, but I don't know, TN 5000, but under a totally new brand name. Okay, so this is a supplier's, but this product doesn't have that S mark that usually inspires trust and comfort among the consumers. Okay, it has something else.